Huge and biggest discussions are going on on US immigration current decisions in which children of H1-B work visa, which are over 21 years of age, they are asked to leave US instantly, and they are declared illegal, and they are declared undocumented, and they have been told that you have no any status inside United States, you are not eligible to stay in United States. So discussions are going on, families are worried, and their children are going to separate from their own parents. So they are very victims. They are thinking they are victims, and they are just going to lawyers as well, and they are thinking that anybody will provide them justice, and they are talking with the lawyers as well. Now the US Immigration Department and US administration, the Trump administration, developed a legal point to save their saying, mean that whenever they are deciding on immigration, definitely they are following the legal rules and justice system, because each country, and America has powerful justice system. When immigrants will not get justice from the government, they normally goes to courts, and the judges decide. Therefore, they are planning to move to the court. But now, what the US immigration system created a point due to which I don't think the justice system may be able to defend the children of H1-B work visa, because H1-B work visa families, a lot of Indian families and other families coming from Asia, coming from different parts of the world, Venezuela, Vietnam, Africa, they are living and they are living with the families, and their children are over 21 years age. They are males as well as females, and when their children are being told by ICE police in the school and colleges that you are undocumented, when they are telling no, our parents are US green card holder or US H1-B work visa holders. But remember one thing, if the parents are citizens, there is no problem. If the parents are citizens, according to US laws, all children will get the US nationality and US citizenship. There is no problem. But if the parents still on H1-B work visa and they did not get citizenship of United States, so their children also have the same status of H1-B work visa, dependent status, mean family, F1, F2 status. But these children who are dependent of H1-B work visa, mean their parents are not US citizens, their legal status to stay in United States according to these rules are finished. Which point US immigration system raised, they refer that dependents can stay in United States. Dependent of H1-B work visa holders, according to US laws, families can stay in United States because you are dependent and you have complete legal rights to stay if you got US family visa. But they are telling we are not stopping dependents. We are stopping those individuals who are not dependent. So this is very interesting discussions in immigration, and I am very keen to learn these things, that kids are dependents and over 21 years they are dependents or not dependents. Now that this definition the US immigration did in US laws, which judge I think will keep notice that over 21 years, according to new law, judge will be told by Trump administration, this is the new law, that over 21 years age, they are not dependent. Now this discussion may be in the courts, that who is dependent and who is not dependent, and discussions the lawyers will do that over 21 years they are also dependent. But I think Trump is at very safe side. The Trump administration is at very safe side. USCIS is also at very safe side, because they discovered a point, a very strong point. When anyone is over 21 years age, he is not dependent. He is liable to earn his own money. He is liable to live his own life, because now he is not getting money from the parents. He should not get money from the parents. He should have been his own identity. He should have been his own job, and they are giving opportunity, and they are giving point that any man who is over 21 years age, either man or woman, she should get job. She should get his salary, and she should be able to sponsor herself or himself. According to immigration system of US in current new rules, if they are not able to sponsor mean that if they are not able to sponsor themselves and they are still dependent upon the parents, they are no more US immigrants, because we want only, because they have made very simple formula, the people who are useful for them, they're gonna stay in United States. The people who are useless and they are not doing any services to the US citizens, to the US state, they may be deported. So that's the point they have raised, that the person, the kid, when he was under 21 years, he was supposed that he's getting education, he's getting professional skills, and he is supposed that he will be having time to get those skills to be required to serve in United States. But over 21 years, he is not able to review his own status, and he is not able to make his own legal status in United States as a worker visa, because they want over 21 years age must have their own work visa if they are working in any company. And two ways by which these children can stay in United States. Number one, their parents became US citizens. Most of H1-B work visa who are living from since 10 to 15 years in United States, they normally became citizens. This is also a question that the people coming from overseas, the children, they wonder why their parents were not citizens since 10 to 15 years, because H1-B 21 years age student mean it's a huge age. Might be his parent is working since 10 to 15 years. Why he did not get the citizenship? Because as I told you, when parents got citizenship, their kids are safe. Even they are under 21 years age, they are over 21 years age, all will get citizenship according to US rules, immigration rules. But these families are suffering, those families are suffering whose kids came late in family reunion visa, because there are very tough cases for family visas. Some people, I remember, they are waiting 1 year, 2 years for interview slot, and some kids do not apply for family immigration visa in the start, and their parents were living for 10 years, 15 years, and then later on they apply. Such families will suffer. The families who have their children 10 years back, their parents got citizenship, and their children, even they are over 21 years age, they don't come under these restrictions. But still, many families are thinking to go to the court, and they are making their own point. Now, who will win? Trump administration will win the case, or those people will win the case that they are telling that over 21 years age, children still are over dependent. But I think in US laws, over 21 years should not be dependent. In my opinion, they should not be dependent. Reason is one, because when you will say over 21 years kids are dependent on the parents, nobody will work in any country. If the kids will not be given chance to work, if the kids will not be given open field to select their job and to serve parents and to serve the country, they will remain idle and they will become jobless. I think these students, these kids who are under 21 years age, when they are very closer to 21 years age, they must start hunting jobs in USA in different companies, because they got education and they got skills, and after getting jobs they must change their status from H1-B dependent visa to H1-B work visa, main visa. That could be the solution of the problem. I will keep informing you. Thank you very much.